What's going on, everybody? Greg Dawes, GD, non-attorney pro se consulting. I guess you might be able to see it down there in the corner, but it's not really that important. What I wanted to do today was to speak directly to veterans about an issue that is so bothersome to me that I don't think that I'm the only one affected. At least I can't be the only one affected just based on the information said by an attorney for Officer Roll Basketball in a court proceeding. Now, for those who don't know, I'm not an attorney. I don't have a license to practice law. I do not practice law. What I've done is studied the law and tell people what I learned, how to gather the information. I don't give the information as advice to apply to specific cases, but it's general information regarding the law and lawful principles, which, by the way, belongs to the people. So please use any information obtained from this PSA educational edification only, and for veterans to spread the word to other veterans. And so, again, it's solely for educational edification only, and for me to get the word out to more veterans because of what's happened in my life, and I'm sure with other veterans. I'm speaking specifically in this instance, and I can do other videos as well if need be, about my situation with the 13th Judicial Circuit in Hillsborough County, Florida, as it relates to an automobile negligence case between myself and Chandra and Linda Tucker. In that situation, the Tuckers were represented by Officer Roll Basketball of Professional Association in Tampa, Florida. And I'm pulling up this information so that I can show people, because I don't want anybody ever take my word for it. And if you go into the docket, you'll see some things. So let me pull up some transcripts for the people. And this is a little bit different than what I am typically, unfortunately or fortunately, known for, as it relates to my case with Austin Rowan Basketball. And I'll also show you all some information from the mediation settlement agreement. So we're going to talk about what we call clean transcripts, and I want to see which one it was, where it would have said we had cases unrelated. Let me see if I can find it. I don't know if this is the right one. And just bear with me, because this is a live, like an impromptu live. And one of the things that inspired this impromptu live was because I had a sit down with an attorney. I'll just say that. And explain to that attorney some of the issues that I ran across in my case. One of the things he said that caught my attention was, he said, well, he kind of, I won't say chuckled and laughed, but kind of like, some things are said and they say sometimes silence is louder than words. And in this instance, his silence, so to speak, was louder than his actual words, to the degree that he pretty much acknowledged that what I experienced was flawed. And when I show you all some of this stuff, you'll understand it as well. The attorney who made the statement actually was an attorney by the name of Mark Fisher, and he does work for Austin Rowan Basketball. And the reason I say their names so confidently is because I'm not lying about these things. But, if there was a lie, there may be an issue of somebody saying, Mr. Dawes may have slandered or what have you, or defamed us. But when it's true, if it's true, what does it say? If it's a lie, let it fly or something. I don't know. But if it's true, hey, it must be about you. So I'm going to make sure I pull this up. Each one of the ones that I appeared in front of Fisher with. And let's see if I can find the word unrelated before I show you all. Making sure I'm just bear with me. Okay, this is not the one, so I can take this one down. And I'm going to tell everybody, if you ever go to court, and you make sure if you have attorneys, which I highly recommend people get licensed attorneys to help them with their case. In my case, as I explained to the gentleman, been unable to find any attorneys that would be willing to help me with my case, which is it could be, it's troubling. And most of what I have learned is because of what I couldn't afford to pay for or what I couldn't get anybody to do for me. Um, okay, that's not it. So, and I have several of them in here to go through, but I've learned more about the law, which was never my intention, uh, more about the law through peripheral information than what I was actually looking for. And so, what I'm doing with these, okay, here we go. I found it. So now let me go ahead and pull this up for you all. This was on 5/1/2021, and it's on page 11 of, okay, come on, here we go. So now I can pull up and show you all what I'm talking about. So as you can see the proceeding, and this is what a transcript looks like. All it is just an official recording. So here we go. Mr. Fisher, thank you again. I have to address Mr. Dawson's motion he filed past Friday. Everything I just mentioned, I think is contemplated with this subject of Dr. Shim. Okay, I've already laid out the reasons that the court should grant our motion for protective order. Now, here's what's crazy. They're asking for a protective order for Dr. Shim. And by the way, they don't represent Dr. Shim in this case. They represent the people, the lady who hit me and her mother. The lady who hit me, her name was Chandra Tucker, and her mother is Linda Tucker. So why is an attorney filing next for somebody he doesn't represent? Maybe you can ask an attorney who'll come on and they'll explain some of what I'm looking at. Mr. Dawes had the CME. He goes to get evaluated at the VA one day, and it turns out he's evaluated by Dr. Shim. So what you can tell by context is Dr. Shim performed a compulsory medical examination. For those who aren't familiar, if you're in an automobile accident, whether I guess you're at fault or I don't know, I wasn't at fault, but anyway, rear-ended by Chandra Tucker on January 16, 2017. State Farm wanted me to go see one of their doctors. I go to see one of their doctors for them to evaluate. So in the process, I walk into this office. I don't know who Dr. Shim is at this time. I just figured he's a doctor for State Farm. He evaluates me for State Farm. Shortly thereafter, as you can see by what's on your screen, I go to the VA for a regularly scheduled appointment. And as you can see, Dawes had to see me. He goes to get evaluated at the VA one day. I was going to an appointment. And it turns out he's evaluated by Dr. Shim. And no mention in that record is there any discussion about, hey, this is a conflict. Dr. Shim, why are you evaluating me? Because at the time that I saw Dr. Shim in the beginning, I did not know he was a VA doctor. No one disclosed this. And furthermore, while this jackass is speaking, he's the one that when the VA told them to pound sand about getting my record, stated they worked with this guy before, and you're going to see that. Dr. Shim remembers that he had a CME with Mr. Dawson. I'm just guessing at that one. She shouldn't be guessing. But by the way, Dr. Shim is not his client, so he shouldn't be really speaking about it. But that's something for attorneys to talk about. And I go to the objection. You hear me object. But in any event, has now hold on objection to this. I think they closed me out. That there's some sort of conflict here, and our firm is committing some sort of fraud in his basis. He sat through an entire evaluation with Dr. Shim after the CME and now claims there's a conflict. Again, a misrepresentation. I didn't know who Shim was for whatever until after he saw me. And so it's a combination from what I understand. So he goes back down and it says, well, you explain why did I misunderstand or something happened? I think it's a combination. This is from Miss, and Mark Fisher is the attorney for the Department of Revenue. I mean, he's the attorney for Chandra Linda Tucker, who was hired by State Farm Automobile Insurance Company solely for the purpose of representing the Tuckers and their liability in the accident. From what I understand, Dr. Shim volunteers his time at the VA. whether he volunteers or whatever, he's a VA doctor. It said he does not work for the VA. The VA paid him, he works for the VA. That's what I understand. According to Mr. Dawson, we were required to disclose to him that Shim volunteers his time at the VA. So that's my understanding. Here you go, people. We've had several cases, other unrelated cases, where the plaintiff treats at the VA and gets a CME by Dr. Shim. No issues from the plaintiff's attorneys in those cases. So here we go, people. Not me. Not me alone, at least. So what you just witnessed is where the problems kind of began in this case. And I'm just saying, if there's any other veterans who may have not known that our doctors were compromised. I have no issue with the fact that a VA doctor may have an outside practice. That's okay. And I think all of us veterans would have no problem with that, because we know the VA probably doesn't pay him what he can make in private practice. And none of us are telling these guys to sacrifice and be broke or not reach their maximum potential treating veterans. The issue is whether or not your association in both of these matters violates not only our protections as veterans under federal law, not to mention it could be some HIPAA violations, but I want to get into that without any specifics to address. I don't know what he did or did not do. And of course, I couldn't get any discovery in the subsequent lawsuits because Judge Paul Huey shut him down. And then the Second District Court of Appeals in Florida had, operated by holding the water for him and has so far denied me access. So I'm thinking my only alternatives are through mandamus to the Florida Supreme Court, or to ask the Florida Supreme Court to exercise discretionary review, which I doubt they're going to do, because essentially it's either going to be this one guy who's a veteran is so very right, and because all the evidence and the information supports that he's accurate, and that would be okay, except you have judges in the 13th Judicial Circuit, attorneys in that work for Boston Road Basketball Professional Association, Banker Lopez Gassler, and Butler Wymuller, Cass and Craig, which combined have over 300 attorneys, are all crooked under the umbrella of State Farm, or we're just going to make this one guy seem like he's far-fetched in what he's saying. So what I'm going to do, just for some clarity, let's see what this thing is. I'm going to show you all some exhibits that are part of the, and by the way, everything that I bring up in this video, you can actually get out of the public record because it's just there. I want exhibits there. Looking at the transcripts, I don't want the transcripts. So let's go to something else I want to show you all. And these are things that I've been meaning to get to, but I've been so busy. I have a case in here up in Atlanta, in the 11th Circuit Court of Appeals, the federal courts, involving, if you go to my GDNAPSC.com website, you'll see my houses were stolen. Well, what kind of came from me defending my properties is why I ended up, it kind of brought me to this case here in a roundabout way. Essentially, in 2017, I was charged with perjury in an official proceeding, and I self-represented one, but only after disqualifying several 13 Judicial Circuit judges, and ultimately the Florida Supreme Court sent a judge in from outside the circuit, and that judge dismissed the perjury case against me, citing among other things, there's no materiality, which is a necessary element of perjury in an official proceeding. The bigger issue being that a so-called judge, who my argument when I sued him was that he had no jurisdiction, so that's why I could sue him. He had no jurisdiction fully. I couldn't sue him in his judicial capacity. I'm saying I'm suing him because of who he was as an individual. He just happened to be a judge, and that he, along with this officer, denied me freedom from search and seizure. I ended up winning the case nevertheless, self-represented, and I did not have to serve 5 years in prison, which was the maximum penalty had I been convicted for perjury in an official proceeding. And the number of things that could have went left had I gone to prison, not just for me, but for my family, is why I will not ever stop fighting these people. So anyway, that being said, really quickly, let me show you all exactly what is the major issue. And I would definitely, somebody knows how to do I won't say GoFundMe, 'cause I don't really like to do those. I've never done them before, so I guess I don't like to. Never done one before, but somebody who could show where, who could help me bring more light to what's happened, not only with this case, but other issues. The houses, the properties today have a combined value of, I want to say $1.6 million collectively. And I think I found what I'm looking for. Here we go. So for everybody who's not familiar with my case, let me help you out with this. Here we go. Yeah, this is going to be what we want. So at any rate, I filed this lawsuit back in 2018. The the lawsuit rose from an action that happened in 2017, on January 16, 2017. I tried to resolve it. So anyway, as you can see, this is officially from the court document. Here you go, in the circuit court. So here's the exhibit. Here's the case in question. See this case? That's my given name is Shagret Uraniados. Here are the people I sued. And the reason I show you all this is because it's public record. So it's not like it's some sort of unknown secret when it comes to litigation. So you see the mediation conference was held on October 28, 2021. It was held via Zoom. So as you can see, the agreement releases the following parties, and you can see all these people here, and it says State Farm status is required to satisfy the VA lien. And this went on for a couple of hours before we finally end up getting to this particular settlement. And number 5 is where it becomes important. The plaintiff, which would be me, shall voluntarily dismiss this litigation with prejudice and execute and deliver to the defendants and his or her insurance company through the office. Because, I think you all saw the $30,000 per two, I think, right? Yeah, see $30,000 right there. But anyway, so it's no problem. I had no problem with that. So here's what it's going to get interesting in a second. As number 8 is clear, if all litigants are not present, then the signatories to the stipulation of the parties further agree that they have full and total authority to execute the stipulation of the parties on behalf of any litigants not present at the mediation, and this stipulation becomes binding upon the parties by their execution. Now, what's clear is no one other than myself and the Tuckers are party litigants, and you're going to see where this becomes even more interesting. It shall be filed required by law. Okay, this didn't happen. As you see, here's my electronic signature. This is the mediator. This is the attorney for the other party, for the Tuckers. But these two names are missing. They never did anything. And you're going to say, well, then what happened? What happened is we agreed to a specific set of circumstances, and this could have happened to any veteran, even through your attorney, to a specific set of circumstances. And upon that signature, what should have happened, which is mine, is he should have just tendered the check. He didn't tender the check after I signed it. This right here, I'm going to show you all something here, but this is the release. Let me find. Here's a letter of release. This is what he ended up drafting. Did not give me the $30,000 immediately after the mediation. He drafted this. And as you can tell, just at clear glance, this is not the same thing that I agreed to. So I refused to sign it. And as you see, it's from all manner of actions, causes of action, suits, specialties, all this other stuff. And it says, in demands of any kind whatsoever in law and equity known and unknown, both to the person and property, specifically including any claims to loss of consortium directly or indirectly sustained, and what should make sense to anybody. And you don't have to be, I don't claim to be an expert litigator. I'm just a person who's an expert in life. We could have discussed all this on the 28th. And then it gets a little, and it says, hey, from an incident that occurred. So he want me to say, get rid of anything that may have happened not related to that, so long as it came after this. No, that's not how this works. Now, we could have resolved that. I'm clear with that, and I'm sure you all as well, but then the dollar amount would have damn sure been different. Because now you want me to let you all slide on the criminal activity that you all were involved in. And I'm going to show you why it's criminal activity. And so we go through all this right here. And I'm like, okay, I'm not signing on this. This is not what I agreed to. So let me go back to what I was going to show you all the first time. So if you see this order, the court finds that plaintiff Shagreddal signed the stipulation of the parties pursuant to the mediation conference. Nobody's arguing that. The court orders that pursuant to the settlement agreement. Well, what settlement agreement? The plaintiff shall sign. And what she said in the court is, I'm ordering you to go and sign. If you don't sign, I'll have to, should I fail to sign and release within 10 days of the order, it shall be as enforceable as if I executed the release. And there's the judge. So what I do when I go sign this thing and say, I don't want to sign it, but I don't want to be held in contempt. And for those who don't know, just go do a little bit of research on me. I'm also the same guy at the Florida bar sent a letter to claiming I practice law. Well, actually, it wasn't a claim. They're out. They just wanted to know about an allegation that I'm engaged in unauthorized practice of law. I don't practice law. I can just read anyway, and I have no problem sharing my story. Clearly, on that page, you see right here, under duress. So then we go through this process, which I ended up eventually appealing. And when you go to my YouTube page, you'll see one of my oral arguments where one of the attorneys for State Farm, one of the State Farm attorneys claimed that I signed it voluntarily, released voluntarily. So we have that, but here's something else that everybody needs to pay a little bit of attention to. And I don't think it's showing that, so let me bring you all to this. For those of you who are out here looking, especially you attorneys, I think that's it. Here we go. This is a stipulation of the parties is not a mediation settlement agreement. And as you see in this, I got this out of the Westlaw. I can just pull it up for you live. For those who don't know, and yeah, we do have access to this stuff. It'll take a couple of minutes, but I'll show you how we do things here. Just for clarity purposes, and again, anybody who wants any of the information, you're free to just ask me for it. I'll send it to you. Hell, it ain't like it's some kind of government secret. And let me go ahead and take a look at this right here. And it'll give me a couple of seconds, but it's going to come back with what I just showed you all. It'll take a couple of seconds, and I've already pulled it up. So let's do this while we wait, because it may take a couple of seconds for it to prompt me. This is what it ended up producing for me. And it's not a mediation settlement agreement. The distinction between these two types of agreements is significant under Florida law. So now, if they're not the same, a mediation settlement agreement is a specific type of agreement reached during a mediation process, which must adhere to certain procedural requirements. If a partial or a final agreement is reached during mediation, it must be reduced to writing and signed by each party or the party's representative having the full authority to settle. We can go into that. And actually, Florida actually has a rule that states that anybody who's going to appear at a mediation must sign a certificate of attendance and authority prior to showing up. And otherwise, you don't really have any rights under the mediation. And what would have been interesting before I filed my lawsuit is, had they told me that they were trying to resolve it for some issue other than the lawsuit, there's a 99.6% chance I'm not going to show up. Or I'm going to tell them, no, I'm not here for that. Let's just stick to the point. But here we go. Under Florida law, does all parties have to file a certificate of attendance and authority. Yes, 1.72. It's called a certification of authority. And essentially, what it states is the rule, and it's been around for a while, requires that the parties file a certification of authority 10 days prior to appearing at a mediation conference, identifying the person or persons who will be attending the mediation conference as a party representative or as an insurance carrier representative, and confirming those parties have the authority to amend the rule. This is coming from there, but we can get it from anywhere because it's really pretty simple. And if I'm going a little bit quicker, you all can always slow it down when you get back to where you are. And you know what's really kind of crazy is I would probably know about 10% of what I know if people just did the right goddamn thing, which is crazy. Well, that's going to take us back there. But the rule is the rule. You can get it there. It'll be right there for you. So anyway, um, see, this is the right one. Maybe I can use Control F. This might be the wrong one. This is what year? There you go. So there you go. Must follow, and if I object, I have to do something else. But it's actually E. Uh, that's not it. It's the 10 days before they do it, and I had to go ahead and follow it. But anyway, I wanted to get to this thing here. Here we go. So it finally took it. It finally brought it back. Under Florida law, stipulation of the parties is not the same, although the two may share certain characteristics. A stipulation is a formal agreement between the parties in a legal proceeding, often concerning procedural and substantive matters, and is typically filed with the court. Wait, this one wasn't. It was filed as an exhibit, but it actually wasn't filed in the court as such. Mediation settlement agreement, on the other hand, is a result of a mediation process where a neutral third party facilitates negotiations between disputing parties to reach a voluntary resolution. While both are agreements between the parties, they arise in different contexts and are governed by distinct rules. What was pretty clear was that what was supposed to come from that didn't happen. And what I did after that was I filed a lawsuit alleging, among other things, fraud in the inducement, alleging that Michael Rowe and Austin Rowe Baskell called the mediation conference not to resolve the matter between myself and the Tuckers, but to try to keep me from bringing up the issue. And he actually said it in another proceeding. I'll show you in the transcript. He wanted to get this freight train. He said this freight train, he saw it coming down the road. And again, anything that y'all want with this, I can just give it to you. It's really, this wasn't called for that reason. I just wanted to put it out there in the event any strange set of circumstances take place. I want to make sure that everybody knows what's going on. But he happened to have mentioned that he saw the freight train coming down the track and that he knew that I was going to sue them for all the other stuff, particularly Dr. Shim, the issue with Dr. Shim, and and also the fact that you pretty much destroyed my amount of trust I should have with the VA providing medical care. And the VA's been providing medical care for me since in the 90s, when I first left duty in the military. So if there's anything that you would like for me to cover that I didn't cover in this, because I have a couple other things I want to get to, but specifically I wanted to address this one issue and this one live for if no other purpose, to let veterans know that there's some kind of strange things going on out there that the VA owes to us as far as protecting us, and the fact that other veterans are involved in some of these things. I think I just found it necessary to inform veterans to always be on the lookout when it comes to us and people. I know we hear often, and people, I'm sure, many are sincere when they say thank you for your service. I thank everybody who's ever put on a uniform. That includes my mother and father, who are both retired military, my grandfather who served in World War II, my uncle who was a Marine, other uncle who was in the Army. aunt who was also in the Air Force, my numbers of cousins who've been, and other family members who served in the military, especially with the caveat that less than 7% of all Americans have ever served in the military. That's a very unique and distinguished honor that those of us who served performed. And again, when people tell me that, I say it was my honor to serve the country. So that being said, I think we got enough here. As always in closing, sometimes it's not about right or wrong. More importantly, it's about clarity. You'll never reach resolution if you're not willing to engage in honest dialogue. Even if the dialogue is with yourself, take time to hug the person you love the person you hug. On behalf of GD non-attorney pro se consultants, I'm Greg Doss. I'm saying peace. I'm saying chicken grease.